Hello and welcome back to the 2023 Research Conference, Politics, Communication, and Polarization, hosted by the Center for C-SPAN Scholarship and Engagement and the Brian Lamb School of Communication. Just a reminder, please keep your mics on mute. And moderating today's panel is Jake Truscott. Jake is a postdoctoral research associate for the Center for C-SPAN Scholarship and Engagement. He received a PhD in American politics from the University of Georgia. His research principally focuses on integrating computational methods and traditional questions in judicial politics, particularly the U.S. Supreme Court. His work has been published and featured in the Journal of Law and Courts, Justice System Journal, SCOTUS blog, the Washington Post, and the Associated Press, among others. Apart from published research, he recently completed the development of SCOTUS Text, a comprehensive R package for retrieving, cleaning, and parsing documents from the U.S. Supreme Court. Join me in welcoming Dr. Jake Truscott.
Thanks, Andrea. Yeah, I'm happy to see everybody. This is going to be an amazing panel. For those of you that don't know yet, we do have a speaker, so now we can focus on the Supreme Court. I'm very happy about that. Matt thought that was funny. Yeah, I'm very excited. So the papers in this panel seek to shed light on critical aspects of American politics and jurisprudence. We have two amazing presentations from three presenters. The first paper takes a deep dive into the U.S. Supreme Court, exploring the justice's communication with the public beyond the confines of oral arguments and written opinions. This paper is going to delve into the justice's off-the-bench remarks and examine the content of these statements, comparing them with their official duties on the court. By doing so, the study offers fresh insights into how extrajudicial behavior may influence the court's role in American society, and most importantly, addressing a significant gap in the existing research. The second paper is going to explore the intricate relationship between morality and politics, particularly in the context of a long-standing and contentious issue of abortion in the United States. The study focuses on the language used by members of Congress surrounding the Supreme Court's pivotal decision in Dobbs versus Jackson regarding abortion rights. By analyzing C-SPAN footage spanning 3 months leading up to and following the decision, the study aims to unravel the discursive patterns and moral foundations employed by lawmakers in their discussions of this sensitive issue. This research promises to deepen our understanding of how political discourse and morality intersect in a politically divisive landscape. And with that said, our first presenter of the day is going to be Matt Cota. Matt is a PhD student in the Department of Political Science at Michigan State University. He studies American politics with a focus on the U.S. Supreme Court and judicial politics more broadly. His research interests include judicial decision-making and studying judges as people. Matt is a native of Minneapolis, Minnesota, and received his BA in political science from the University of Minnesota. Matt, the floor is yours. We'll be happy to do some Q&A when you're done.
Thank you very much, Jake, for that introduction. Let me just get my presentation pulled up for you all right now. Did everyone see that okay?
I can't see it, no. I don't think anybody.
Let's see here. How about that?
There we go.
There we go. All right. So again, thank you, Jake, for the introduction, and thank you to the CCSE and the Lamb School of Communication for putting on this conference. I'm really happy to be here to present my project titled Speaking Off the Bench, Analyzing the Extrajudicial Speeches of Supreme Court Justices. Now, like Jake mentioned, this project broadly examines judicial behavior outside the court and off the bench, and looks at how the justices communicate with the public. So I want to start the presentation with a quote by a very influential justice by the name of Benjamin Cardozo, who served on the court from 1932 to 1938, and used this quote to sort of set the standard for extrajudicial speech. Cardozo said in the 1930s, "A justice may not talk about the events of the day. They may indicate his judgment as to the problems that will come before him as a judge. He may not talk about the past. He may not talk about the future." And this quote epitomizes that the justices, in Cardozo's mind, should not talk about their law or their decisions on the law really at all. They shouldn't do anything to indicate their judgments, which is how the public commonly conceives of judges and justices, that they are neutral arbiters of the law, and they do not do anything to tip their hand as to how they will decide cases when they are talking to the public. So Cardozo sets this standard with this quote, but my broad question is whether this standard is being lived up to in modern extrajudicial communication. So let's look at two examples given by two justices that have sort of been under fire in the press and from Congress in recent days. Starting with Justice Samuel Alito, speaking in 2006 at a Federalist Society convention, Alito said, quote, "The Federalist Society has clearly become one of the most influential legal organizations in our country by providing a platform for the smartest and most articulate advocates of ideas like textualism and originalism." The second justice who has been under fire recently has been Clarence Thomas, and he said something similar, stating that our role as judges was to be confined to the words of those who drafted the Constitution or enacted the law in question, and what sorts of words or what those words meant to the people when they were drafted. In short, the original meaning. So what we see from these two quotes is demonstrating that the justices are sort of putting their stamp of approval on two methods of constitutional interpretation, going against the standard set by Cardozo nearly 100 years ago, that a judge should not do anything to indicate how they may decide their cases. Whereas these two justices are indicating they will decide cases based on these modes of constitutional interpretation and essentially discussing past cases and future cases by doing so. But is this speech surprising? Not really. And I will walk through why it's not surprising by going through a progression of norms of extrajudicial speech from around the founding of the Republic to modern day. And the first example that we can pull is Chief Justice John Jay running for the governorship of New York. Clearly political speech, clearly ideological speech. And it demonstrates that from the founding, the justices have been participating in the partisan world. In a similar sense, we have Justice Chase campaigning for President Adams in 1800. We have Justice Joseph Story advocating for the Missouri Compromise at a town hall meeting in Massachusetts, where he is from. And finally, capping off the pre-Civil War era, we have Justice McLean openly criticizing President Polk and his policies related to the Mexican-American War. He wrote op-eds to the press, and he was openly critical of the president. Commonly in judicial politics parlance, the justices are thought of politicians in robes, but this era before the Civil War really epitomizes that role of the justices, specifically in how they communicate with the public. Now, throughout this timeline, going from the 1700s to present day, the justices change up how they're communicating with the public. And it's not really known why, but where these changes happen are during some quiet times. Specifically, the first is during the Civil War and the Reconstruction era. The justices did not speak very much. Why that happened is unknown currently, but research is being done to figure out why. But the important part is during these times, the justices change in how they are communicating with the public. Specifically, the content of what they're communicating changes. Justice Brewer epitomizes this changes by talking about the court's economic decisions and transferring what the court is or what the justices are communicating to the public into a more legal sense. They are not talking about politics, they're talking about the law. Justice Brown followed this trend by giving a speech in 1906 where he talked about the Constitution more broadly and discussed his interpretive philosophy. So we see the justices moving from being politicians in robes to more being defenders of the law and defenders of the court in this post-Reconstruction, early 1900s era. Again, we see the justices go through another change in sort of what they're communicating to the public via a decline in their extrajudicial speeches from the Great Depression into World War II. And they change from being sort of defenders of the court to more being educators of the public and being sort of more celebrities. And this is epitomized, the start of this trend is epitomized by Justice Douglas, who was very verbose and very outspoken on the bench. He specifically had a speech in 1958 where he talked about his job as a justice overall. Continuing this trend in the 1980s, Justice Thurgood Marshall discussed his career with the American Bar Association and how his career has changed over the time, moving from Solicitor General to a justice on the court. In more of the educative role, we have Sandra Day O'Connor giving a speech in 2002, where she explained the influence of foreign law on the justice's decision-making, and then capping it off with another sort of more personal side of the extrajudicial speech in the modern era is Justice Ginsburg discussing her life as a justice. So we see this transfer of the content of the justice's speech when they're communicating with the public from purely partisan and political to more legal and then to more educative. When we see this modern era, this sort of late 1900s to our present era as the justices sort of being educators and celebrities, taking advantage of their role as known figures in the public eye. And what this shows is that the justices have always been communicating with the public, but what they've talked about has changed over time. And I sort of conceptualize this as a similar power to that of the president, which is their bully pulpit power. The justices have always used this sort of judicial bully pulpit to participate and communicate wide-ranging and frank out-of-court commentary, but what they're specifically communicating has changed over time. And that's what they're communicating has changed and has led to sort of norms in extrajudicial speech changing throughout the progression of the founding of the Republic to modern era. But the justices still seem to have a desire for exerting some sort of public influence, and that seems to remain constant despite the change in content. Now, the justices, with their desire of public influence, seem to have goals in communicating with the public. First, there was persuasion about politics, then persuasion about law, and then education about their role as justices or their education about the court more broadly. And these goals, from research that shows, specifically Cruson in 2019 demonstrates that the justices are trying to persuade the public to think of the court in a better sense, think of the justices in a more personal, favorable sense. And these reflect their goals that are similar to their goals on the bench and what they are doing with their judicial decision-making. So what this shows and what this indicates is that extrajudicial speech may provide useful information to explaining judicial behavior. But before we can make those connections, we have to determine whether there's variation between their speech on the bench and their speech off the bench. And that's the question I take up in this study, which I asked, do justices speak differently off the bench from how they speak on the bench? To answer this question, we need sort of an underlying theoretical explanation of why we would expect the justices to speak or behave differently on the bench versus off the bench. And to that, I look at their most known form of judicial communication, vocal communication, which is their oral argument remarks. And why we might expect them to speak differently between these two settings is based on classic institutionalist arguments, which is that the rules and norms and constraints of institutionalist settings are going to change the behavior of the actors within those settings. And that's exactly where I situate my argument, where we see that the rules and norms help explain the justice's variation in behavior and speech during oral argument, whereas extrajudicial speech, they're only governed by self-imposed loose norms. There are norms that have progressed in content of speech over time, but there are not actual constraints really in how the justices can speak and what they can speak about. The code of conduct that you all have heard about come up in the press does not apply. The code of conduct for extrajudicial behavior does not apply to the justices of the Supreme Court. So they are very unconstrained in what they can talk about. Additionally, we see that the purpose, along sort of with this institutionalist argument, is that the purpose of oral argument is different than the purpose of extrajudicial speech. Whereas the purpose of oral argument is to help the justices make decisions via information gathering, via argument evaluation, and those lead them to decide their cases in certain ways. Whereas the purpose of extrajudicial speech, in the modern sense, is to educate the public and to shore up support for the court and to benefit the justice's personal favorability. And a number of studies have shown that these are the justice's goals when they are speaking off the bench. This variation in the constraints, rules, and norms between these two settings of speech leads me to hypothesize that the content of the justice's public remarks will be significantly different from their oral argument speech, but there is variation in which justices are speaking when, how frequently the justices speak, so I expect that these differences will vary by justice. To test this hypothesis, I gathered transcripts from the C-SPAN video library. Specifically, I gathered 167 of the justices' extrajudicial speeches from 2002 to 2022. And then I gathered the transcripts of all orally argued Supreme Court cases from the years the justices gave speeches from an external oral argument data scraping source. To look at differences between the linguistic content of these two arenas of speech, I looked at 5 types of language. First, I looked at gendered language, which is I use a novel approach of examining gendered language within the justice's speech by using a dictionary of gendered words developed by Roberts and Uchich that looks at the feminine and masculine content of specific words in general, rather than using gendered stereotypes to look at words. I also looked at 4 other categories of linguistic content derived from the linguistic inquiry word count. And I looked at emotional, political, cognitive language, and the justice's expression of drives. All of these, I will explain why I looked at this type of language in particular in just a moment. To derive whether there are differences between the content of the justice's speeches, I used a simple difference in means test by a Welch 2-sample 2-sided t-test, controlling for word count between the 2 settings. Because as you will see in the next slide, the corpus of words is significantly different between the oral argument speech and the justice's public remarks. There's about 3 million words in my oral argument corpus. There's about 300,000 words in the public remarks corpus. So in order to control for the differences in word counts, I used the 2-sample t-test. But first, I want to show you the distribution of words between the 2 settings. First, on the left side of your screen is going to be oral argument, and then on the right side will be public remarks with the key of linguistic content also on the left side as well. So here, we see that there is variation between the types of the linguistic content just demonstrated by the raw word counts of each word found within the speech or within their oral argument transcripts. And then we see from their public remark speaks, while there is significantly less words, this also indicates in a certain way that there is variation between these 2 settings. But like I mentioned, there are significantly more words in the oral argument corpus than there are in the public remarks corpus. So to control for that word count, I ran a couple t-tests, and I will show you the results of those through a series of coefficient plots that demonstrate the coefficients at the 95% confidence interval. Starting with gendered language, on the left side, we have feminine language. On the right side, we have masculine language. And the coefficients here demonstrate the change in rate of gendered language per 1,000 words when moving from oral argument speech to public remarks. And these demonstrate that for all justices, they use more gendered language in their public remarks than they do in their oral argument speech, but results are significant for only a handful of justices in this study. Just as an example, if we look at the left facet, the result for Sandra Day O'Connor, she uses about 2 to 3 more feminine words in her public remarks than she does in oral argument. Looking at the right facet, masculine language, for Clarence Thomas, about halfway down, he uses around 2 to 3 more masculine words in his public remarks than he does in his oral argument speech. Now, why gendered language is important is that the studies that examine the intersection between gender and politics reveal that gendered language use within groups and by individuals can demonstrate the consequences of gender overall on political communication and the influence of underrepresented groups in decision-making. So what I'm trying to show here is that looking at the justices' speeches from a gendered perspective may be a good way to continue those lines of research and transfer them into judicial politics research. Moving on to my second category of language, I looked at emotional language. We see that for all the justices, except for David Souter on the bottom, all justices use more emotional language within their public remarks than their oral argument speech. This is different from, or the x-axis is different from the x-axis in the previous coefficient plot. This shows the percent change and not the rate change. So, for example, if we look at, say, third from the top, Ruth Bader Ginsburg, she used about a little bit more than 2.5% more emotional language than in her public remarks than she did in her oral argument speech. And now why looking at emotional language is important is because someone's use of emotional language can reveal their intentions, their motives, and desires within their speech. So this signals, along with the next coefficient plot that I will show you, that the justice's speech to the public may be a good way at deriving their expressed preferences to the public rather than deriving their preferences from their votes or from their opinions. We may be able to actually get at what the justices themselves think are important based on their own speech. And another way to look at this is to look at the third category of language I have, which is expressed drives. We see in this coefficient plot that all of the justices express their drives, their motivations, and their goals to a greater extent in their public remarks than they do in their oral argument, again signaling that looking at their public remarks may be a good space for examining the justices' goals overall as they express themselves, rather than using more internal ways of deriving their goals and preferences. My fourth category of language is cognitive language. This is a field of study within judicial politics that is up and coming, looking at the cognitive functions that the justices are trying to derive the influence of cognitive functions on the justices' decision-making process. There's one study by Collins from 2011 that demonstrates that the justices' cognitive dissonance can affect how they write their opinions. So I looked at cognitive language to see whether they were sort of working harder during oral argument than they are during their speeches. And it seems like they are. This shows that the justices use less cognitive language during their public remarks than during oral argument, which makes sense because during public remarks, they may have prepared speech, whereas during oral argument, they're working through cases on the fly, asking questions, getting at it with the attorneys. So it makes sense that they may be using more cognitive language, which may be indicative of cognitive processes and functions during their speeches while they are arguing at the court. My final category of language that I looked at to examine differences is political language, which directly gets at the reason why certain justices are currently under fire in the press, because the members of Congress and the press are sort of alleging that these justices are partisanly biased. And as we saw from the progression of norms in speech that partisan bias from justices isn't anything new. It happened at the beginning of when the court first started. So the fact that it's sort of having a resurgence now is surprising in a certain way, but also we shouldn't be too surprised because the justices have done it in the past. And what this demonstrates is that, or this plot here demonstrates that all justices except for Clarence Thomas are using more political language within their extrajudicial remarks than during oral argument, potentially signaling that the justice's extrajudicial speech may be a good source to look at for examining political bias. To conclude, my results show that certain justices speak differently off the bench than they do on the bench, but this varies by justice and this varies by the type of linguistic content examined. Overall, the presence of more linguistic content may lead to explanations of judicial behavior, whether we're looking at the influence of gender, whether we're looking at the influence of emotion, cognition, or political bias. Looking at linguistic content within their extrajudicial speech may allow us to explain why the justices are behaving in certain ways a little bit better by broadening our scope of analysis from judicial behavior and judicial speech, like oral argument that has been researched, and like the court's opinions that has been researched. Broadening out to extrajudicial speech may be more helpful to explain more broadly the justice's behavior. And finally, what I would like to show is that, or would like to say is that extrajudicial speech, like I mentioned, is a suitable candidate for exploring how the justices express their own goals, express their preferences, and broadly allows us to derive relationships between their on-bench behavior and their off-bench behavior, which will allow us to get a better look at the justices' behavior overall. That's what I have for you today. Thank you very much for your time.
Awesome. Thanks, Matt. So I have a few questions. I have a few comments, but I would like to actually open it up to everybody first. Bryce, go right ahead.
Yes, I just wanted to say that unfortunately I'm going to have to jump off the call, but Matt, this was a fantastic talk. I really did appreciate it, and I will send you some questions via email because very well presented, and also I like the design quite a bit. So I look forward to seeing more of your work in this area moving forward. So thank you so much.
Thank you very much. I really appreciate it.
Robert, go right ahead.
I know this is part of a larger work, but did you look at the audience at all? What group they would speak to?
Yeah, I did look at audience. I collected where they spoke and what the setting was that they spoke at. So I have the descriptive data available, and that's something that I can dig into a little bit more. And like, there's research on where the justices have traveled and showed so they travel to give speeches mostly. But I do have data on the audience, yes.
Because they tend to speak to judicial groups, law schools, things of that sort. I just wonder in the earlier data whether you had broader audiences than what I see in my C-SPAN life, where it's more narrow.
No, you're absolutely right. They do tend to speak to more legal oriented audiences like law schools and the American Bar Association. A frequent one that we would see is they give these little talks actually in the court's chambers. And we also see that they would give term overviews. At the end of a term, they would review the cases with a particular society that is assigned to a circuit court. You'd have Chief Justice Rehnquist who did this a ton. He went to the same hotels in West Virginia year after year. He'd switch hotels and he'd give the same speech about the court's cases. But yes, it's more legally focused, and it's we don't see them too often speaking to a broad audience. It's definitely focused on law.
I know when Brian interviewed Rehnquist in front of the court on his book, he read at the beginning sort of the rules that Rehnquist gave him, but you can't ask me this, this, and this, and this. You know, so anyway.
Yeah, they're very particular about what can and won't be talked about, but it seems that that might be changing with recent speeches. They're beginning to give a little bit more ideologically driven speeches.
All right. Well, if nobody else has anything, I just have just a quick comment and then a question before we kind of move on. The one thing that I would recommend, just from going over the study real quick, kind of piggybacking off what Robert was saying, if I was going to get this paper in a journal, the first thing that I would be thinking is exactly kind of what Robert was pointing on, like what's the variation in the setting, right? Because I would imagine that the general angst or any kind of controversy that's popping up with extrajudicial speech today isn't really kind of focusing on Kagan or Sotomayor giving lectures or Q&As at law schools. It's Thomas and Alito going to FedSoc and railing against everything, right? And I would imagine that if you threw that descriptive data into the model, at least if you controlled for it, you'd probably get some variation. And that's a really cool kind of point to make, where if you can show definitively that, especially someone like Alito, who is very verbose in argument and also very verbose off the bench, if you can still show that there's a lot of variance of what's going on, or even if he's doing the exact same things, that's a really hard-hitting piece. And that's something that I would 100% recommend for publication, right? So yeah, just an idea going forward on that. And kind of branching off that, a quick question for you. Why do you think that this stuff is becoming more tumultuous? Because you said it yourself, that giving speeches off the bench or engaging with audiences off the bench, well, it's not entirely common. It's not completely something that's never happened before. He knows there's obviously some translation or at least transition over time. So why do you think today people are paying a lot more attention to this?
I think it has to do overall with the court probably feels threatened based on their recent decisions. And judicial politics research shows that the justices rely on what is known as a deep reservoir of legitimacy to make their decisions. And I think that they overall see that reservoir shallowing or declining. They are losing legitimacy with the public. So in their own ways, whether it's Kagan going to a liberal arts school and bashing the Dobbs decision, or whether it's Sam Alito, he gave a speech where he railed against foreign leaders and supported the Dobbs decision. I think the court is trying to shore up support with their camps a little bit more in modern era, because they see that they're losing support from their own camps. And we're losing this sort of neutral arbiter of the law look on the justices. And I think that they're, at least Kagan and Chief Justice Roberts are really trying to bring that neutral arbiter role back by broadly talking about the court, but also trying to show that the court is a legitimate institution and is not deciding things based off of politics, but in their own ways, in their own camps.
Very well said. Appreciate it. Does anybody else have any questions before we move on to the next presentation? No? Well, thank you, Matt. Thanks, appreciate it a bunch. That being said, moving on, our next presentation is by Diane Jackson and Dr. Jennifer Howie. Just to give a brief introduction to both of them. Diane Jackson is entering her third year as a doctoral student in the Brian Lamb School of Communication at Purdue University. She is interested in the intersection between political communication, media psychology, and technology. Her research is about the processing and communication of political and politicized information. Specifically, she studies the way that political partisanship influences how we process, communicate, and engage in partisan news media consumption, political misinformation, and activism around politicized topics. She's also interested in the way that these phenomena differently impact individuals and communities who are marginalized. Dr. Jennifer Howie is an associate professor in the Brian Lamb School of Communication at Purdue University. She studies media psychology and political communication. Specifically, her research program focuses on how political issues and groups of people are depicted in the media content and how these depictions influence media consumers, particularly in terms of their cognitive processing, their attitudes, and their identity. Dr. Howie has published more than 45 scholarly publications and has won several research and teaching awards. She is the former head of the Communication Theory and Methodology Division of AEJMC. Additionally, she is the founder and director of the Media and Politics Research Group at Purdue. She holds a courtesy appointment in Purdue's Department of Political Science, and she is a member of the CCSE Advisory Committee. Well, with that being said, I'm going to go ahead and throw it over to Diane, and please, all yours.
Thank you so much, Jake. Okay, just give me a second to share my screen. Okay, can everybody see this okay?
Looks great.
Awesome. Thank you. Okay, hi everyone. Thanks so much for coming. Like Jake said, my name's Diane Jackson. I'm a PhD candidate in the Brian Lamb School here at Purdue, and I wrote this paper with Dr. Jen Howie, an associate professor also in the Lamb School, and we conducted this study of the ways that Congress spoke about abortion leading up to and immediately following the Dobbs versus Jackson Women's Health Organization Supreme Court decision that was made last year. So I will start by providing a really brief overview of the history of abortion legislation in the United States. So abortion legislation began in the mid to late 1800s. So abortion legislation in the US has been around almost as long as the country has been established and independent from Great Britain. So state laws were introduced around this time, introducing restrictive abortion laws in the mid to late 18th or 19th century. And then in 1973, the Supreme Court struck down a Texas abortion ban on the basis that it infringed on women's constitutional rights to privacy. In the decision that we know as Roe v. Wade, that effectively legalized abortion in the country. And then in 2022, the Supreme Court heard the Dobbs versus Jackson Women's Health Organization case, and they reinstated individual states as the legislators of abortion rights, overruling Roe v. Wade and the Planned Parenthood versus Casey case. So, though partisan divides in voting and framing of abortion issues did not arise until the mid to late 1980s, when the Republican Party began voting more consistently against abortion in an effort to demonstrate pro-family values, these divides still exist really strongly today. So where we see pro-choice rhetoric tending to refer to females in abortion narratives as women, we see pro-life rhetoric tending to refer to females in abortion narratives as mothers. And similarly, pro-choice rhetoric tends to involve the safety, privacy, and rights of women, whereas pro-life rhetoric tends to center around the harm and defenselessness of the unborn child. Further, despite public opinion polls over the past 20 or so years demonstrating more US adults supporting the legalization of abortion in all or most cases, research showing that language used by pro-life organizations tends to pervade more of the media coverage and framing, as well as more of the public discourse on Twitter, for example, as shown here. With these things at play, we were curious to see how Congress members talked about abortion, both in terms of the emphasis that they placed on either the mother/woman or the child, and in terms of the moral foundations that they emphasized. So moral foundations theory was the cornerstone of the study that we conducted, and sorry about that. Moral foundations theory was developed to study the underlying structures that form individuals' morality. And prior research has illustrated that moral foundations application across cultures and contexts. So moral foundations theory proposes 5 moral foundations that are listed here. So care and harm is the first one, fairness versus cheating, loyalty versus betrayal, authority versus subversion, and finally sanctity versus degradation. And research shows that political parties emphasize these foundations differently, as politically liberal individuals are more likely to focus on individualizing foundations. And politically conservative individuals tend to focus more on binding foundations. However, given the emphasis that pro-life frames of abortion have used on the care and harm of unborn children in media coverage and on Twitter, the goal of this study was to understand whether Congress members' uses of moral foundations in their discussions of abortion tended to coincide with this existing research. So that led us to pose the following research question: how did members of Congress use moral language to discuss abortion surrounding the Supreme Court Dobbs versus Jackson Women's Health Organization decision? So we collected data by searching the C-SPAN video library for mentions of keywords abortion, Dobbs, Roe, pro-choice, and pro-life. Our time frame included 3 months leading up to the decision and 3 months immediately following the decision. And our sample included all videos within the US Senate and House of Representatives series classification. So we ended up finding 29 unique videos, 4 which were from the House of Representatives and 25 that were from the Senate. And this produced 215 distinct speeches from single members of Congress about abortion. So 129 of these speeches came from the House and 86 came from the Senate. 78 were given by Republicans and 137 were given by Democrats. And we used Luke, linguistic inquiry and word count, like Matt did, which is a text analysis software and which quantified our data with existing or self-made dictionaries and their associated variables. So we used an extended moral foundations dictionary to code each of the moral foundations. And we also used a custom dictionary where we counted terms relating to women and children. So results from a MANOVA that we conducted, examining the relationship between the speaker's political party and the moral language that they used in their speeches, indicated that there was a statistically significant difference between the ways that Republicans used moral language and the ways that Democrats used moral language. So we examined the between subjects effects, and we found that Republicans and Democrats specifically discussed fairness in significantly different amounts, where Democrats used the moral foundation fairness significantly more than Republicans tended to. So I have one example of a Democrat who focused on fairness here. This is a speech that was given by Democratic Representative Sylvia Garcia of Texas on July 13th, 2022. Okay, so this was one example from Sylvia Garcia. Can you all see my screen now?
Yes.
Okay, great. Okay, and then we also found, according to another MANOVA that we conducted, that according to the speaker's political party, that women and children were also discussed in statistically significantly different ways, according to the political party of the speaker. So when we dug a little bit deeper into this, we found that as prior research has shown, Democrats discussed women statistically significantly more than Republicans, and Republicans discussed children significantly more than Democrats. So there were a couple of examples here, one from Democratic Representative from Washington, Kim Schreier, who gave a speech about women. She's a doctor, and so she talked about the rights of women who are pregnant and seeking an abortion. and then also by Republican Representative John Joyce from Pennsylvania, also a doctor, who gave a similar speech, this time oriented toward the development of the unborn child. And so practically, of course, this study and its focus carry numerous applications. Given how long pro-life and pro-choice rhetoric has existed and the polarized conditions that have persisted from the time that these partisan divides began in the late 1980s, political parties may find that their rhetoric regarding abortion necessitates updating. So incidentally, there was an NBC News article recently reported on a closed-door strategy meeting that Republican senators had regarding their framing and rhetoric surrounding abortion. So they were meeting to discuss the recent poll results that indicated that voters reacted differently to phrases like pro-life and pro-choice in the wake of the 2022 Supreme Court decision, and that the phrase pro-life no longer resonated with voters. So the article cited senators like Josh Hawley, Kevin Cramer, for explaining that more specificity, is needed for Republican politicians when they're talking about their stances on abortion, because voters tend to see pro-life as being against all abortions. And so they agreed that more specificity is necessary. Senator Todd Young went so far as to reframe his stance to be pro-baby, to demonstrate his concern for babies. And of course, reiterating our findings here that Republicans tend to focus significantly more on babies and children than on women in conversations about abortion. So as we continue in this post-Dobbs versus Jackson decision, it'll be interesting to see how political parties continue to frame and reframe their stances about these topics. So thank you all so much for listening. So sorry about the audio for those clips, but I appreciate your patience.
Nice job, Diane. Thank you so much for presenting. It was really amazing to hear. We do have a few minutes for Q&A. If there's anybody who wants to ask a question, I obviously have some. I'll be more than happy to keep the conversation going, but does anybody in particular want to ask anything to Diane or Jen? Yeah, Robert?
Yeah, I just had a question about your search criteria. I saw the 4 words you used, and you said you found, maybe 200 somehow, so many videos. Did you search on mentions at all? Because you could uncover more speeches under mentions than you would under videos. I just you can think about that, and we can talk more about it later. But there's the basic search would get if there was a reference put in, but like, let's say the whole house may not have spoken about debated anything about Dobbs, but somebody spoke about it. So it depends on how you did your search.
Yeah, I think that it included mentions, but Jen would be able to speak more intelligently to that.
Okay.
Yeah, we specifically looked at the classifications of U.S. Senate and U.S. House of Representatives, and then put in all those different words within those classifications, and that was what came back.
But did you click on the mentions part? Because that gets individual speeches as opposed to whole events.
No, we just did the videos.
Okay. Because you might get more cases under mentions than you would under whole videos, but you got a good sample.
Yeah, thank you. That's great to know.
Mm-hmm.
Anybody else? Well, I have a question. Okay, so this is very well done. This is awesome to read. I really like that people are doing work on Dobbs, especially outside of just law reviews, which has been the overwhelming majority of this stuff so far. So it's very nice to see empirical work looking at Dobbs, and not just the aftermath, but also kind of the predecessor, the pre-occurring stuff as well. But the question I had is more of like the longitudinal developments across your data set, because you do 3 months before and 3 months after. There's obviously going to be that weird shock that first week of May when the decision leaked. I was wondering if you start to see any kind of substantive differences in these talking points as time progresses, because I would imagine that at least in that first month or so before the decision leaked, you're going to have a lot of like hypothetical, a lot of we don't really know if the court's going to do this, because I mean, just from people that I've talked to, no one believed this would actually happen. They've been saying this for years. If it was going to happen, it would have happened by this point. And when it finally did, it was just obviously a massive development. But I was wondering if you saw that reflected in the data at all, that longitudinally you see substantive differences in what Democrats and Republicans are saying as potential becomes reality.
Yeah. Jen, do you want to take that question?
Sure. So prior to May, as you were saying, there wasn't much being discussed. And then after that, there was quite a bit. We didn't see any difference. So we had a variable coded for pre and post of when the decision was. There wasn't really much to look at before May, but with the decision we looked pre and post, and there weren't any differences in the variables that we looked at. So specifically the moral foundations and the use of language related to women and children, there weren't any substantial differences between the pre and post time.
That's actually, wow, that's actually really, I wouldn't expect that. Huh. Is it maybe just because there's limited amounts of time to speak on the floor, or do you think it's just in general, do you think that's more or less the relationship?
I mean, it could be. I think it also just could be that Republicans and Democrats kind of had their focus from the get-go and didn't really deviate from it. So the fairness component, right? And then also the focus on women's rights for women's, fairness for women for Democrats, and then for Republicans on the unborn person, fetus, that focus, I'm guessing, was just pretty consistent in the way that they were deciding that they wanted to talk about it. So again, just in terms of the variables that we were looking at, I didn't see a big shift in it. And that, my guess is that's why they probably had their rhetoric pretty well thought through, I would guess.
Thank you. Robert, do you have something?
Yeah, let me just make sure I'm clear. You've got the leak decision and then you've got the formal decision. So are you working on both of those, or just the leak decision? Which
We're
order
looking
are
at
you working on?
the formal
decision.
Mhm.
Okay, so
But
there
that
could have
leak
been. Go ahead.
But the window did include both. So it
Yes.
went from March to September. Yeah.
Okay.
They would have included that in May.
Yeah.
Mm-hmm.
It included both, but that before and after point I was talking about was the decision.
Mm-hmm.
Does anybody have anything else? Well, thank you so much for presenting, both Matt, Diane, Jen. It's been an amazing time. Thank you so much for bringing your research. Hope to see you next year. I don't know. Andrea, I think it's yours.
Absolutely. So thank you, Dr. Truscott, for moderating this insightful session. And thank you to Diane and Matt for these thought-provoking presentations.